Hello and welcome to the first outline webinar of 2026. If it's not too late in the year, Happy New Year to all our viewers. My name is Trevor Ivory. I'm a partner in the planning team at DLA Piper, and I'm joined today by my colleague and legal director in the planning team, Amy Truman. Hi,
Morning.
Amy.
Hi.
And today we're going to be talking about all things change of use related. So various different knotty issues that we see come up regularly in practice around changes of use. As ever, if you do have questions, the Q&A function is available, so please do ask your questions and we'll try to deal with as many of them as we can as we go along. And at the end, we will certainly be within an hour. We always try to be within between 45 minutes and an hour, but we will guarantee we don't go over the hour to keep everyone's diaries intact. So without further ado, let's get started. So Amy, I suppose sort of changes of use, we've kind of got to start with why we worry about changes of use at all, don't we? Which takes us to our good friend, the Town and Country Planning Act 1990 and Section 55 of the Act, which sets out what is development for the purposes of the Act. And the reason that's significant is because planning permission is required for development. So do you just want to start with a sort of talk us through what does Section 55 rather tell us about changes of use in the context of development for which permission is required?
Yeah. So Section 55 tells us that in terms of what is development, it's the making of any material change in the use of buildings or other land. The point here that I think we'll come back to many a time during this session is that it's a material change, not just a change in use. So that is always a starting point. The second main point is probably that we do have the use classes order, which then schedules various uses into use classes. If you change use within a use class, that is not taken to be development. I think those are the overriding points on.
Yeah, I think that's
starting points.
I think that's right. It's the fact, isn't it? That Section 55 says that obviously operational physical works are development, but also material changes of use. And that word material is really important to me. I think the point is there are always two questions you have to ask when you're looking at whether a change of use requires planning permission. Firstly, is there a change of use? And if there is a change of use, is that change of use material? If it isn't material, then planning permission isn't required because it's not development for purposes of the 1990 Act. And I think we had quite a good example of that, quite an interesting example of that, certainly a very high profile and controversial example of that, that was front page news at the back end of last year, which is the Epping Forest case, which many people would know was the case looking for an injunction, local authority seeking an injunction against the continued use of a hotel in Epping Forest as a centre for the housing of asylum seekers. It was high profile, and ultimately the Court of Appeal rejected the injunction that was being sought. We're going to put all of that to one side because we're not talking about the injunctions and enforcement today. But at the heart of the High Court decision was the question of change of use. And so I think that's quite an interesting example where, for me, the judge was looking at the question of had there been a change of use from a hotel use in that case. And it seemed to me, Amy, he was pretty clear that there had been a change of use. It seems to me when you read the judgment, there were a number of factors, weren't there, that he thought meant that the character of the use was no longer as a hotel.
Yeah, so I think it was pretty clear that he felt that the character of the change of use was from a hotel to a hostel. I think what's quite interesting about this is that a hostel used to be in the same use class as a hotel, but is now moved out to sui generis. So at one point, this question would have been clearer, but now obviously it is a different use, and so the question really is whether the move from a hotel to a use as a hostel was a material change of use. It didn't actually decide on that point in the High Court case, but it did make it clear that it's a matter of planning judgment as to whether that material change of use has occurred. And that to look at that, you need to look at the character of the use, and it's all about looking at fact and degree as to that change of use to decide whether or not it's material. So
that was the critical point for me, and he looked at a number of points that he took into account to conclude that there had been a change of use. He looked at the fact that the occupants of the hotel didn't get a choice as to whether they were in the hotel or not. They didn't get a choice of room. They were forced to share, but to share with another, not sort of within people of their choosing. There were limits on their ability to leave the hotel. And all that sort of stuff. So he was pretty clear that this was not a hotel use. The character had changed, and as you say, had changed probably to something that looked like a hostel. But I think the really interesting point for me was that whilst he was absolutely clear that there had been a change of use, what he wasn't prepared to do was to decide whether that use was material. And so, as you say, very much was saying that materiality was ultimately a matter of planning judgment, and therefore not a matter for the courts. It was in due course a matter for planning authority or an inspector on appeal in an enforcement proceedings to determine whether that change of use was material or not. But that for me was a sort of a useful reminder of a long-standing principle that just because there's been a change of use does not mean that there's been a breach of planning or that there is a requirement for planning permission. You've got to always think about materiality. And in that, you've sort of mentioned the use classes order already, and we all know changes of use within a use class are not material and therefore do not require planning permission. But I think what Epping is a reminder of is a principle that goes back a lot further. The RAN case, I think, is one of the early authorities on the point that just because a change within the use class is not material does not mean that a change that takes you outside of a use class or into a different use class is automatically material. And that's sort of Epping, isn't it? As you say, hostel is sui generis, hotel is within the use classes order, but the fact you're moving out of a use class and into a sui generis use is not automatically a material change of use. That's a judgment that needs to be considered by the decision maker in one form or another.
Yeah, that's right. I mean, I think the RAN case is quite interesting in that it definitely makes this point about the changes of use between use classes not necessarily mean that there's been a material change of use. And so I suppose looking at all of these, a lot of these cases seem to look at either domestic or hotel and hostel use, and there is always this blur between these uses. There is quite a lot of overlap. So the trigger for how it becomes material, even if it is described differently, is what's important. Not really that description, but actually the character of the use is what is important. And I think that probably leads us on to the point that it's the character of the use, not only on the sites that you're looking at, but also how that affects off site.
Yeah, I think that's right. And there's a sort of line of cases which I think is interesting to look at around the question of what is material then. How do you begin to assess materiality, accepting that it is always a matter of planning judgment. So there isn't a sort of legal yes or no. Ultimately, it will be a matter of planning judgment for a decision maker to decide. But there are, I think, a line of cases, particularly around intensification of use and the question of whether and when an intensification of use can itself constitute material change of use, that help to demonstrate what needs to be taken into account with materiality. And I think for me, you kind of the line of cases, and by the way, all the cases we refer to today, because I know there are a number we're going to chuck in and already have, we'll circulate the full references to the audience to the live stream, and we'll also make them available in the notes on the YouTube version of this broadcast. But I think the 1962 case of East Barnet is a good place to start. And I think we can take these pretty quickly, but what comes out of East Barnet is the principle that it's the character of the use that needs to be considered rather than the purpose that the occupier of property is is intending. So in that case, it was I think from memory, it was storage of materials, and the material changed that was being stored, and the purpose which is being stored changed. But what the court said was that that isn't a change of use in that circumstance, because the character of the use as that storage use was still materially the same. So the starting point for thinking about whether a change of use is material is to look at the character, not so much looking at the intention or the purpose of the landowner or the occupier of the land who's carrying out the operations. That sort of is a good place to start. And if you then sort of fast forward a few decades, I think the next interesting one in terms of that sort of intensification argument is the Lilo Blum case in 1987. And what that said was, yes, intensification can in principle constitute a material change of use. So the fact that the use is the same, but you are just making a more intensive use of the site, can still get to a point where it constitutes a material change of use. But the question that the court was emphasizing in Lilo Blum, it is whether the intensification is such that it changes the character of the use. The fact that you're just storing more there, or the fact that you're just have more customers coming through the door, or whatever it is, doesn't in and of itself constitute material change of use unless it changes that underlying character of the use. So sort of really building on East Barnet. And then the question then, I think, is well, okay, character is clearly where we start, but to what extent do the effects and the impacts of the use contribute towards character? And the Manning case in 2005, sorry, that looked at that question, and the court there concluded that the impacts of the use are part of the character, they're integral to the character. So when you're looking at the question of has the character changed, you're not just looking at what's actually going on site, but you are able to take into account what the impacts are of that use off-site. And if the impacts change, then that is and can be evidence that the character of the use has changed so as to constitute a material change of use. So I think that starts to give us a sort of a framework as to how you look at materiality. You look at the character, including the impacts that the use is having, both on and off-site. And I think the Herefordshire case in 2012 was a Court of Appeal case, wasn't it, Amy? And I think that's sort of quite a good example that pulls together those principles from the older case law.
Yeah, it does. It was a scrap metal yard that basically intensified by doubling its throughput of what it was doing. And so it was doing the same thing, but twice as much of it. And they looked at whether the intensifications cause a material change of use. And they took into account the character of the use, and specifically not the particular purpose of the occupier, but the character of the use. So that sort of cements what we've already been saying. And then the effects that they looked at, bringing into it, being as part integral to the character of the use, included off-site effects. So things like the noise from the dealings with the scrap metal itself, and the increase in traffic. All those things were off-site effects from the intensification of the use that were relevant to look at when considering whether or not there's been a material change of use. So I think that's quite a good case to sort of exemplify what we need to be, the sort of things that we need to be looking at. But the other thing that occurred to me when looking at Hertfordshire is that this is a scrap metal yard, so a sui generis use. Quite often, we would be looking at uses within a specific use class. So their intensification would be allowable because it would be sitting in that use class. So it's only the intensification of uses that take them outside a use class or are outside of use class that is going to trigger this development being undertaken and planning consent being required.
Yeah, it's a really good point. It comes back to that sort of fundamental principle. If you're within the use class, you're not material.
Mm-hmm.
It's when you're out. So the intensification is probably more relevant to sui generis type uses, isn't it? And I think it shows that the Hertfordshire case for me shows that the bar is quite high for intensification. There was a doubling of throughput in that case, and
Mm.
the court was not persuaded that the decision had been right to say this is a material change of use. Although the activity levels had significantly increased, that wasn't enough to have changed fundamentally the character of that use. So I think it's a helpful reminder that it's quite a high bar, that materiality, um, in the context of intensification, certainly. So we've got okay, so we've got the sort of basics there, I hope, in terms of how do you begin to approach materiality. It's about character, it's about impacts. Um, but I suppose the next question for me is when does a change of use actually occur? Going back to that first point of has a change of use occurred? When in time? And that can be quite important in a number of cases. A number of different examples, and perhaps we'll come on in a minute to look at them. But I think the important point that I want to draw out is that the case law is very clear that a change of use doesn't necessarily require actual use for the new use, in order for there to have been a change of use. It's ultimately a matter of fact and degree in each case as to whether you're sufficiently close to the point where you're able to change the use, without actually having to have started it. And that goes back, I think, to the Impey case in 1984 is an early case on this point. And in that case, the court said the question isn't are the premises being used? The question is, are they usable for the purpose? And if they are usable for the purpose, then that is sufficient to mean that a change of use has occurred. Um, and I think that the Supreme Court then subsequently, more recently, considered Impey and endorsed the principles of Impey in the Welling case in 2011. And I think it's worth sort of looking at what the Supreme Court said there. The Supreme Court said that one should ask what use the building has or is of if it's viewed in the round. So they talk about that sort of look at everything in the round to judge use. It's not just about what is the actual use that's going on, and there doesn't need to be at a particular point in time an actual use taking place in order for you to determine what the use is or whether there has been a, a sort of a change of use. And I think that sort of there's some interesting examples of that. You've got one, haven't you? Which is from the sort of COVID pandemic era, earlier this decade, the Jones case, which actually only
Yeah.
came. The judgment is quite recent; it's 2024, but it goes back to COVID, when of course use was a tricky
Mm.
concept in the middle of a national lockdown.
Yeah. So I thought it was interesting, although I think it probably very much turns on its facts. But so what happened was they tried to change a listed building from a cricket clubhouse to a visitor centre. They had planning permission to do so, but then it was challenged that it hadn't been implemented. And what they looked at was what had been done and whether enough had been done. Because obviously, so the date for implementation would have been right slap bang in the middle of COVID times, at a point where it wouldn't be legal to have the public going into this building and meeting. So, but they had undertaken all the internal decorations and refurbs and everything to be ready for opening. And so that they found that that was sufficient for the change of use, even though it hadn't actually been used as a visitor centre that it was permitted for, because it couldn't be used for the visitor centre it was permitted for. So, yeah, clearly going as far as they could at that point sufficed to change use.
And what sort of factors were the court looking at there in terms of saying they'd gone as far as they could? Were they looking at the physical works? I think they were, weren't they?
They did, yes, they did look at the physical works. I suppose if the physical works hadn't been done, it wouldn't demonstrate any intention to be implementing that consent. So they had looked at the fact that they had decorated and refurbished and got it ready for what they wanted it to be next within
Yeah.
their implementation period.
And it's interesting to me, James, because intention does come up, and more quite often intention is sort of the courts are reluctant to look at intention in planning. And we've just talked about that in the context of whether a change of use has occurred. It's sort of right back at the beginning of this session, we were saying it's about the character, not about the purpose. So, but the court there did take account, I think,
Yeah.
and place quite a bit of weight on what the intention was, given that, then as you say, it was in that specific case where you were legally unable to actually use it. So I suppose that sort of is why perhaps intention is more relevant. But that
Yeah,
felt to me an
I
interesting
think
point.
so. Yeah, it feels like a sort of fair outcome for this case, that they couldn't have done any more. So how could you get there? So I do wonder though whether it is stuck to its facts to some extent.
I think that's right. Although I think what's interesting when you read the judgment is it does draw on those established principles in IMPI and others. So I think it's drawing on established principles, but the particular circumstances clearly were unique in terms of the circumstances of being legally unable to operate, which hopefully isn't a situation we will face again anytime soon. There are other examples as well, though, aren't there? And I think where it comes up quite a lot is in the context of some of the prior approvals under the permitted development rights and the permitted development order, where you have the prior approval processes for conversion and change from one use to another. Class Q is one that comes up quite a lot, which is change of agricultural buildings to residential. And there's an interesting appeal decision. There are a number of appeal decisions on this. There's an interesting one that I came across when preparing for this session from 2020, which was the Hill appeal decision. And that was looking at what was Class O, which was conversion of office to resi. And the PD rights changed since, but it was looking at former Class O. And what had happened there, the facts of the case where you had an office block, there was a prior approval to convert it into flats. The reason this comes up all the time with prior approvals is because whereas planning permissions, there's a date by which planning permission development needs to have been commenced when you implement the planning permission. With the prior approvals for change of use, there's a 3-year period by which the development needs to have been completed. That's an important distinction, because it's not enough to have started the works to change the use. You need to have completed the change of use. And so this question of, well, what does that mean? What do I need to have done to complete the change of use? I.e., do I need to have actually changed the use and commenced the use by that point? Is critical. And you see it quite a lot, because 3 years isn't a long time to get these things done. And in the Hill decision, it's not a case. It's not binding legal precedent. It was an inspector's decision, but in that case, the approach the inspector took, and as far as I can see, it wasn't challenged. The inspector, what had happened was that 1 or 2 of the flats had been completed, and I think 1 or 2 of them may have been occupied, but the remainder of the building, the works to convert the office to residential was still ongoing, and so the majority of the building, the use for residential had not commenced. And what the inspector said there was, well, that was enough to have completed the development for the purposes of the words of the permitted of the GPDO. And that very much drew on some of those principles of looking at, well, actually, part of the building now is in residential use. The rest of it is well advanced in terms of those works, albeit they're not completed. And so on that basis, applying the sort of the principle that you don't have to have actually got people in, he was content in that case to allow it. Now, that's a surprising decision, I think, on the face of it, when the requirement is to have completed the development, and when the development by definition is a change of use, the physical works that need to be done to alter are not, they're not in themselves the development for which the prior approval is sought. Prior approval is sought for the change of use. So I think it's an interesting example of the fact that you don't have to have commenced the use. And in fact, in that case, his view was even though some of the building was not yet capable of being occupied for residential, that was sufficient to have changed the use of the building in its entirety to residential, in order that you had met the requirements of the prior approval process, and particularly that 3-year period. So I think it's as I say, not binding case law because it's an appeal decision. I couldn't find case law on this particular point around any of the prior approvals, but there are a number of appeal decisions which tend to follow that theme of accepting that you can have effected the change of use, completed the change of use, notwithstanding that you haven't commenced actual use in all or part of the building.
But that almost seems on all fours with the case law on the abandonment of use being so difficult to show, and also that by that point, I suppose they did have people in 2 flats, sounds like, and they perhaps gone far enough that it wasn't an office anymore. I mean, there's a tipping point, isn't there, as to which the building had changed, so it couldn't be used as an office without going backwards, I suppose.
Exactly right, and I think it is relevant there that you're looking at the building in its entirety rather than the individual flats. The building's use has changed. I don't know enough about the detail. There's not enough detail in the appeal decision to get to the bottom of it. But once you've put 2 flats in the middle of the building, presumably it's then very difficult to just sort of use the rest of it as office if the works are already underway to subdivide that office and do the other things that need to be done to accommodate. So I think there's a similarity there with your Jones case, in that the works have got you to the point where you're no longer able to use it for its previous use. Therefore, you have changed its use. You've changed that character of the use, notwithstanding you haven't put anyone in all or part of it yet. But it's interesting, and I think certainly one though where practically whenever I'm advising on prior approvals, I wouldn't fully rely on that. I would always take the cautious approach. Get as much done as possible within that 3 years. Let's not be too cavalier about it, because you just want to avoid being in the position where there's a dispute as to whether you've properly completed the change under the PD right or not. So I wouldn't rely on it, but it's another example, I think, of the fact that you don't necessarily have to have commenced actual use in order to demonstrate that a change of use has occurred. I think one of the other topics that comes up quite a bit, and I think causes quite a lot of confusion, is the question of mixed uses and flexible uses, and the distinction between the two. So I'd like to have a discussion on that, but it's probably worth just first of all being clear what we mean when we talk about a mixed use permission and a flexible permission. I think there's no sort of statutory definition, there's no case law definition of this, but my definition, and Amy, shout if you disagree, my definition is a mixed use planning permission is a planning permission that authorizes the operation of 2 or more uses together, effectively as a composite use. So within the same space, the ability to use it for different purposes alongside each other. That for me is a mixed use permission. It's not. Sometimes people talk about a mixed use permission where when actually you look at it and it's not a mixed use permission, it's just a permission for different types of development. So I don't know, you might have permission for a shop with a flat above. To me, that's not a mixed use permission. That's planning permission for some retail space and some residential space. They just happen to be dealt with within the same planning permission, but the uses aren't mixed. There's a very clear delineation between the area that is for residential use and the area that's for retail use in that example. So it's more a mixed use permission is when you are looking at a single space that is capable and being permitted to be used for multiple uses. In contrast, a flexible planning permission, flexible use, is one that is permitting alternative uses of the same space. So where you effectively have a choice, you're being given planning permission for new building, and you're being given the choice as the developer as to whether that building is used for one use or another use, not the ability to run both uses concurrently as a composite use. So that for me is what I mean by mixed use and flexible use. Do you agree, Amy?
Yeah, yeah.
Yeah.
Confusing, but yes, it's
And
quite nuanced there between the two.
it is confusing, and I think, but for me, one of the things that you then need to bear in mind is just looking at flexible use planning permissions for a minute. That planning permission, so the or you can use the space for this or that. You have the choice as developer, as the person bringing forward that development. You have the choice as to which one of those you implement. But the planning permission of itself, once you've made that choice, you're stuck with that choice within the terms of the planning permission. So the planning permission doesn't allow you to sort of keep flipping backwards and forwards forevermore. So use it for, let's say it's flexible use for, we'll stick with retail and residential because we've already talked about that in mixed use. You couldn't use it for a year as residential and then flip back to use it as retail and then flip back to residential again the following year. You are making a choice as a developer when you implement that planning permission. When you commence the use, you're making the choice as to which one of the options you've been given in the planning permission you're going to go with. However, there is a permitted development right, which is, I think, part 3, class V of the PD rights, which says that if you have that form of flexible planning permission, then you have the right to continue to flip between the two for a period of 10 years. And there are some limitations on it. There are not many, but there are some. It doesn't apply if it's betting shops, and it doesn't apply to planning permission granted before about 1988. But
yeah, and it also that those caveats also refer to conditions on the permission. So if you have
conditions on the permissions,
permission, you need to be careful just to make sure you didn't.
Quite right. But on the face of it, you have that PD right to flip backwards and forwards between the flexible uses you've been given. The point I want to draw out here, because it's one that's so easily overlooked, and I've seen it overlooked a number of times, is that PD right only lasts for 10 years. So when you get to the end of 10 years, whatever use is going on that date, that becomes the use moving forward. And I've seen this in the context of a shopping mall where there was a flexible permission that allowed the space to be used. This was sort of pre-Class E, and it allowed it to be used for either retail or office. And it was in use as retail at the 10th anniversary point. And my client wanted then to flip it into office subsequently, and was somewhat shocked when the planning authority said you can't do that because you no longer have a flexible permission because your PD rights expired. So I kind of just wanted to flag that there is a difference between a mixed use and a flexible use. And if you are a flexible use, it's only flexible for the planning permission itself. It's only flexible on day one, subject to the limitations, including planning conditions. There is a permitted development right that continues that flexibility for you for a decade, but at the end of that decade, that flexibility falls away. So it's an important one to keep in mind. If you have the benefit of a flexible planning permission, there does come a point in time where you need to make a choice that is a once and for all choice on that, which use it's going to be moving forward. Any thoughts on that, Amy? Sorry, you gabbered on for a while there.
Not really on the flexible use, I think.
No. The other aspect, I think, which comes up sort of back to mixed use permissions and question of mixed uses, that brings in, and we're sort of coming back to intensification to an extent here as well. It brings in the concept of an ancillary use, which is another concept that isn't defined in the planning legislation, but which comes up regularly in the operation of planning in practice. And also you see it quite a lot in the case law, don't you?
Yeah, certainly do. So we quite often have these questions about, I suppose, whether it's mixed or whether it's an ancillary use. and it probably comes back again to the points that we've touched on of fact and degree as to whether something's an ancillary use or not.
And the relevance of it for me is if a use is ancillary, then it doesn't constitute a change of use, doesn't constitute a material change of use, and therefore you don't need planning permission for it. That's where it seems to me most of the disputes come from. Is it an ancillary use, i.e., can I do it without needing to apply for planning permission, or is it more than an ancillary use? At which point you're into the question of, well, is it therefore a material change of use that needs planning permission?
So I was quite taken with the Harrods case, which looked at whether a helicopter landing on the top of Harrods would be an ancillary use. And the inspector thought that, there's no difference between that and a car park, which on the face of it, So if it was a car park, none of us would be questioning whether it was an ancillary use to a department store if they had a basement car park. But this, when it was tested in the courts, actually they found that it wasn't an ancillary use because it wasn't ordinarily incidental. I think that's quite an interesting caveat on what is a ancillary use. And it wasn't ordinarily incidental because it was unusual, but because also it would have an effect. The noise of the helicopter, it has more of an effect wider than you would be expecting from your department store. So there is a little bit of a caveat there on how you class something as ancillary, even though on the face of it you might think it is. Just as in whether it's extraordinary or unusual, it might just take it out of that. Which again, I mean, this is one very much on its facts. We don't normally look at helicopter landing on offices. But
it seems to me it's sort of coming back to that point about the character of the use, isn't it?
Yeah.
And the impacts with a helipad on the roof are presumably very different, and therefore, back to that question of is the character of the use changing? So it seems like that's partly there. I think as well the Harrods case, which is sort of one of the high-profile cases on this area, but it's drawing on some more established principles. I think Birdle, for me, which is a 1972 case, that sort of answers the question of what does ancillary mean? Because as I said earlier, there's no definition in the legislation. The court tried to set out a definition in Birdle, and I think it's broadly been used since. And what the court said that to be ancillary, a use needs to be subordinate in scale, function, and purpose to the primary use, and also needs to be reasonably necessary to the primary use. And that I think that you can see Harrods has taken that. Is it reasonably necessary for a department store to have a helipad on the roof? Even your average customer in Harrods is probably not arriving by helicopter. So do you need? Can you reasonably argue that you need a helipad in order to operate a department store? Self-evidently not. It seems to me, even if it is a bougie high-end department store like Harrods. So I think that test is a really important one when you're looking at what can I do. I've got planning permission for a particular use. What other uses can I make of this alongside it that are ancillary, and therefore I don't need a further planning permission for? It is that question of looking at the nature of the relationship between the ancillary use and the primary use, looking at whether it is subordinate. And I think there are loads of appeal decisions on this, where that decision is having to be made as to whether something's ancillary or not. I was kind of flicking through them, and there are some good examples. I think one that I came across deals with it's a B8 warehouse that has an office within the warehouse, and the planning authority had tried to enforce against the office use, and the inspector's conclusion there was that the office was clearly ancillary, and in making that decision, the inspector had taken into account the fact that the office was being occupied by people who were involved in the running of the warehouse. They weren't doing other things unconnected with the warehouse. People weren't visiting the office as a destination in its own right, distinct from the warehouse. And so looking at it, and also it was relatively modest office space. So sort of taking all of those factors into account, the inspector said, no, this is clearly ancillary. It is reasonably necessary to allow the warehouse to function, that it has an office, and that is in fact what is happening. It's not a sort of a more standalone office use, and therefore in that case the inspector was happy to find that it was ancillary. In contrast, I've had another one that was a B8, and that was a yard, a sort of storage yard, and over the years it had sort of the use had evolved into a sort of a split use where there was manufacturing going on as well as storage and distribution. And there, the inspector looked at it and found that the manufacturing wasn't a requirement of the storage and distribution. It was more of a standalone use, therefore wasn't subordinate to and wasn't reasonably necessary for the primary use. So in those circumstances, he held that actually what had happened was there'd been a change of use to a mixed use, where the space was being used for both for both manufacturing and B8 sort of storage distribution uses, and so therefore not ancillary, therefore potentially a material change of use needing a planning permission.
Yeah,
the other one I found. Oh, sorry, you go for it.
I was just going to say, I think it's all about the tipping point of one of one use potentially overtaking the other, or more concentration on one use.
Yeah,
so that
I think that's right. It's those two things. Is it overtaking, but also is it reasonably necessary to enable the primary use to be carried out? A good example of that I found was a garden centre which had put a car wash facility into the car park for the garden centre. And that was enforced against. The garden centre argued that that was ancillary to its A1. This was pre-Class E again, ancillary to its A1 retail use. And there, it wasn't so much the scale of the operation that the inspector had a problem with, but it was the fact that it was just that, well, you just don't need this in order to be a garden centre. It's not an inherent part of being a garden centre. You need a back office, so therefore, if there's an office sitting behind it, you need an area of storage. So if there's storage, then that's inevitably ancillary to a retail garden centre. But running a car wash in the car park isn't sort of that reasonably necessary part of the test. So for me, it's those two things. It's the scale, and it's the link, the need for it. I've seen it quite a bit, sort of trying to bring all that together, because intensification, I think, sometimes comes into ancillary, because I've seen it a bit in situations like, for example, if you've got a restaurant that does a bit of takeaway, then that's fine, but it might get to a point where the takeaway is no longer ancillary. Actually, it's got to the point where it's intensified to a level where it is no longer subordinate and is either the dominant use or is a more mixed use. So again, it's all about that planning judgment, but it's one to be careful of with an ancillary use. Even if it's ancillary to start with, if it builds a momentum and grows, it is capable of moving out of ancillary and becoming a material change of use.
Yeah, it's that creep that might be forgotten about because you thought you were okay doing both because one was ancillary. And then intensifying that ancillary use.
Yeah. There's a Scottish case, isn't there? The Cameron case on Scottish ministers from 2020, which deals with Scottish use classes and things. So it's a bit different to what we're used to in England. But that intensification of an ancillary use constituting a change of use comes up there, doesn't it?
Yeah, so that's where guests were staying in the house. That was considered ancillary at the level it was, but then it took over to the extent that it basically became more like a hotel, I think. And that was tipped into, that was its main use. And therefore, in the Scottish law, it was a material change of use requiring planning permission. It might not be found quite the same under our use classes, but that was definitely having the occasional person to stay versus actually this is how this residence is used all the time, to have permanent guests all the time. So that was the difference. And I imagine that was a creep that suddenly overtook at some sort of tipping point of now it's no longer primarily someone's residence.
Yeah, the occasional short-term let was fine, but if suddenly it's always being used for short-term let, it's no longer a house. It's become a, a bed and breakfast hostel, I think,
Yeah.
is the category in Scotland, isn't it? Although I don't profess to be an expert. We've had a question come in, which is a tricky one. So the situation is that a building has been completed, presumably. I mean, I guess that means constructed, which looks as if it's got maybe a flexible permission for B2 or B8. It hasn't yet been occupied, and there's interest from an operator of a paddle centre, which would be, I'm going to rely on the questioner to know this, E subclass D. I will take his word for that without having class E in front of me. So the question is, does the building need to be operational as per its authorised use before the change of use application could be submitted? I think, if I'm understanding the question right, I think the answer is no. If you're accepting that you need planning permission for the change of use, I don't think you need to have occupied the building for B2, B8 before you can apply for that change of use. I think you can apply for the change of use at any point, and if the planning authority is acceptable, or if it's acceptable to the planning authority more accurately, then there's no reason why you can't do that. I think the situation is more tricky if you were looking to use a permitted development right to change from one use to another. And there clearly isn't one that's relevant here. But if you were looking to use PD rights, that's a more difficult area, because you need to have commenced the use, the initial use, before the PD right applies, that would allow you to then change that use. And at that point, I think you're back to the discussion we had earlier, which is the question about, has the change of use been implemented? And that doesn't necessarily require actual use. But if you were in that scenario where you had planning permission to build one thing, wanted to change the use using a permitted development right, then I think you'd need to look very carefully at the circumstances to make sure you've done enough to have commenced the original permitted use in order that your PD rights apply. And you're probably at that point into the situation where you may want to get the comfort of a certificate of lawfulness to make sure that you've done that right, and that the change of use isn't going to fall outside your permitted development rights and be unlawful. But I think the answer to the question is, if you're going to make an application for a change of use, I don't see why you couldn't do that regardless of whether you've commenced the original use or not. Do you think, Amy?
Yeah, I agree. I think on a standalone planning application, it's the future use that is the concern, not what it's changing from, but what it's changing to will be the issue. So I think it's almost irrelevant what it is now. It's just whether the new use is acceptable. But agree, if it is a PD right, you would need to have a use to change from to be able to suction onto the PD right. But you did just bring up a certificate of lawfulness, which I think, when we discussed this, was the point that we thought would be useful in many of these scenarios, just because a lot of these scenarios that we've touched upon are looking at fact and degree and character. If you want to be certain, the way to get that certainty without having to have an explicit consensus to try and get a certificate of lawfulness. How heavy you think the position is?
I think that's right, and I think if you decide that if the change isn't material, therefore you don't need planning permission, you go ahead and do it. If the planning authority disagrees, then you're at risk of enforcement action. Now, at that point, you can have the argument retrospectively in an enforcement appeals scenario, but that can be quite messy. And also uncertain, because potentially if you lose, you've got to unpick the change of use and go back to whatever you were doing at the outset. So quite often that certificate of lawfulness, having that argument, if necessary, up front, establishes and gives you certainty around it. And I think that's particularly important if you're looking at a letting, or if you're looking at financing or disposal, because at that point, anyone doing their due diligence will ask you the question, why have you not got planning permission for this change of use? How can you be certain that that change of use isn't material? And unless it's blindingly obvious, you're creating issues for yourself in terms of due diligence if you don't have an answer to that. Whereas if you've got the certificate of lawfulness, that is your definitive answer, that can knock that issue on the head. So a really good point, Amy, I think to draw out is a lot of this, because it's planning judgment, the only way to be absolutely certain that your judgment is the same as the planning authorities, and ultimately it's planning authorities' judgment that probably matters, is to get that certificate and flush it out. And that way you can proceed without risk, and your due diligence in due course is so much smoother than is otherwise the case when you're trying to persuade a proposed lender that it's all fine and tickety boo, and they say yes, but can you prove that? So very, very good point. We've had a off the wall question. What's the most interesting case about change of use you've worked on, and why? Any thoughts for you, Amy?
No, I think when these things come up, I think it's always quite interesting looking at sort of the ancillary uses and whether they are actually ancillary and how they all fit together, and looking at ancillary uses versus mixed uses. I think the fact and degree always makes it interesting.
Yeah, I think for me, I had a case which actually we resolved via a certificate of lawfulness and an appeal in the end in order to get the certificate. But that was a situation which kind of brought about this question of mixed use versus flexible use, in that we had a planning permission that was pre-Class E, so it was a pre-August 2020 planning permission that had allowed construction of a building and had allowed the floors, had expressed the floors to be permitted as either retail or office space. And so post 2020, the building, some of it was in retail, some of it was in office use. The client wanted to utilize its Class E rights to have that flexibility of the wider use Class E. And the planning authority were resistant to that. So a certificate of lawfulness was submitted. The planning authority concluded that it was a mixed use planning permission. And because it was a mixed use, and a pre-Class E mixed use, under the transitional provisions that introduced Class E, that mixed use is a sui generis use, and therefore is not, it didn't fall into Class E when the changes happened, notwithstanding the fact the two uses were retail and office. Had it been a mixed use, the planning authority would have been right to say that. But the point we made was, no, this isn't a mixed use planning permission. This is a flexible planning permission where we have a choice whether we use the space for either office, which would have been at the time B1, or retail, which at the time would have been A1. Therefore, it is now a use Class E, and the slight catch with mixed uses doesn't apply. And ultimately, we were successful on that, and we got our certificate and got confirmation that we had a planning permit. We had a permitted use that was effectively use Class E, and therefore we had all the flexibility to move within the various different components of Class E. So that was an interesting one for me, drawing out that distinction for the benefit of the planning authority who didn't get it initially, between a mixed use permission and a flexible permission. One last question, which we might be able to squeeze in before we come to the hour. If internal works to a building do not require the benefit of planning permission, how does the interplay of this work when determining if a change of use of a building has occurred, i.e. the internal works have been done but haven't yet submitted a change of use application? Any thoughts, Amy?
I mean, I'd say it's dependent on whether the character of the use has changed, of the unit, of the use, the fact and degree of the change of the use has occurred. So I suppose if you're not changing anything internal, there's nothing obvious to demonstrate that other than actually using it. So the Jones case that we talked about earlier, they had made internal changes, and that was deemed to be sufficient because they can open to the public to change the use. But I suppose if you've just got a building that looks like it used to look, you're not using it for anything else until you are actually physically using it for something else, I would say.
I think that's right. I think to me it depends on the nature of the internal works. I mean, if I'm sitting here in an office building, if you'd done a whole load of internal works that meant that this room I'm sitting in looks like a lounge and has a kitchen off to that side and a bathroom off to that side, the fact I haven't moved anybody in doesn't necessarily mean that I haven't purported to change the use of this building from office to residential. And in that case, given that you don't need to show actual use, in that case, you may have effected a change of use. That change of use may be material, in which case you may well find yourself have carrying out unlawful development. So the principle that internal works don't constitute development, therefore don't need planning permission, is absolutely clear and settled. But if, in effect, those works are not just standalone physical works, those works are works that are in order to effect a change of use, then potentially the mere fact you've undertaken those works could constitute a change of use, which if you haven't made your change of use application by that point, which I think the question indicates is the case, then you potentially are carrying out unlawful development and are at risk of enforcement action at that point.
Yeah, and I think if you think about Trevor's case that he talked about earlier, where they were changing, I think it was office to dwellings, and they'd done a couple of flats, and then they'd made the other internal, they were making the other internal changes. That was deemed to have got to have changed the use.
There are parallels there, yeah.
Yeah, I think you could draw in those parallels, perhaps, as to how far you go.
Well, that brings us just up to the hour. And as I said at the beginning, we will finish within the hour. So that's a good time to draw it to a close. Amy, thank you for joining me, and thank you for your insight and input. As ever, thank you to our audience for joining us today. We will circulate details of the cases, as I said, and we'll also provide the link to the YouTube version of this broadcast once it's uploaded, so that if you've enjoyed it that much, you can watch it again or share it with your friends if they haven't watched it and you think they should. We'll be back soon for our next episode, which will look at the Planning and Infrastructure Act, which received royal assent and is now on the statute book as of late last year. So hopefully you will join us again soon for that topic. But in the meantime, thank you very much and goodbye.
Thank you.